Today's case is a dramatic tightrope walk between redemption and incarceration. Meet Jamie's story, a repeat offender who was given a rare second chance, probation instead of 10 years in prison, but just months in, she's already violated it 7 times. Now the court must decide, should a woman with an extensive criminal history and a recent string of no-shows get another shot? Or is it time to revoke probation and enforce the full sentence? Stay tuned, because this hearing has raw emotion, legal firepower, and one powerful plea that might just change everything.
All right, ma'am, you're Jamie Story, and this is cause number 23, DCCR 1546. Ms. Story was placed on probation February 25th of this year for the offense of theft of property with previous convictions, and that was enhanced to a third-degree felony. The sentence was a 10-year term in prison that was probated for 10 years. Motion to revoke was filed. We were here before, and Ms. Story pled true to all of the counts 1 through 7. I've received the updated report. Have all of you had an opportunity to review that?
Yes, Your Honor. I have your.
And are there any additions or corrections?
None from the defense.
Judge, my only thing that I would add, just for the court's recollection, and obviously I, of course, would not hold the court to this.
Let's break this down. Both sides are painting vastly different pictures of Jamie's story. The prosecution reminds the court that even agreeing to probation was a stretch, citing her criminal history and past bond issues. Meanwhile, the defense leans into her vulnerability, homelessness, fear, and lack of resources. What's fascinating here is the balancing act, the legal system trying to assess not just behavior, but intent. Did Jamie deliberately blow off probation, or was she drowning in circumstances she couldn't control? Here's a question for you. Should the court prioritize past failures or future potential?
We had some difficulty originally even getting her on probation. She volunteered a couple times. We kind of, based on her criminal history, made a stretch to make the offer. The court was inclined
Don't talk over her.
to go along with it based on some circumstances regarding her homelessness, etc. I do appreciate that she took responsibility for a motion. However, I have a note on my original plea papers that the state would be asking for primarily the max on the motion to revoke. But again, I know Ms. Holmes has an argument with some her times that she's fallen on, and I'm not ignorant of that. I just want to let you know my position, what it was originally.
I appreciate that. Ms. Holmes?
Yes, Your Honor. I believe originally that was my concern with Ms. Story essentially having probation was her lack of resources, in which she continued when she was placed on probation in February of this year. That came to fruition. She originally was at her brother's home. That didn't work out, and then she went to go to Liberty with a friend, and there was pretty much lack of resources, lack of transportation, and she made the decision to then not contact because she got scared, and here we are. Your Honor, my main argument is that she has not been on probation long to get started. She never has gotten started. Now that she's been in custody, they visited with her at the jail to let her know what steps and what resources that they can provide, so she knows that she does have help if she does fall on these hard times, that is what probation is for. We are asking if she could get that opportunity to get started so that she can get the resources and the help. She states that she's been in contact with her mother, and her mother would be where she would reside if she's reinstated back on probation to get things back on track. I do see in the recommendations that probation stated if she is granted reinstatement to complete the cognitive track of the intermediate sanctions facility, in which I've gone over that with Ms. Story, and she is willing to do that to have an opportunity to get back on track with probation. Your Honor, we do understand she does have extensive criminal history, and this is not her first rodeo. However, we are asking, due to the severity of how long she can be sentenced to prison, that she at least have one more opportunity to start probation and get back on track and get the resources that she needs.
I don't have anything additional, Judge. I defer to what the court deems appropriate.
I mean, what's appropriate is for you to go to prison for 10 years, probably, with your history and the fact that you got this chance in the first place, right? I mean, probation has all the resources to help you, but they can't go find you and force you to take advantage of those resources. That's up to you. You've been on probation, you've been revoked on every probation you've been on. So the fact that we gave you a probation now and that I'm even considering leaving you on it is making me question my sanity, honestly.
This is the courtroom moment where everything shifts. The judge lays it bare. Frustration, disappointment, even sarcasm, saying this leniency is making him question his own sanity. Jamie's response? A heartfelt, almost desperate apology. She admits she failed, promises to change, and even mentions a newborn granddaughter, the plea rooted in real life. But here's where it gets tough. Is remorse enough when there's a trail of repeated violations? Or is this a sincere turning point? Comment below, would you take the risk and reinstate probation here?
Do you have anything to say?
I'm just sorry for disrespecting y'all.
I mean, when you never show up, it's pretty much like you're just flipping us off, you know,
I understand.
for giving you an opportunity. And it's hard not to take it a little personal.
And I really am sorry, and I'm sorry for disrespecting y'all, and I will do it right this time.
What will you do different?
Everything.
Like what?
I'm gonna get me a job, I'm gonna go to work, I'm gonna go to probation, I'm gonna pay my fees, I'm gonna do everything that I'm asked to do.
Why didn't you do it before?
I didn't have a ride.
Well, but you could always call,
I understand.
right?
It's not my-
You know, if you don't have a ride again, what happens?
I'm gonna have to go on and call. I just had a granddaughter born, so.
All right, I'm going to do this. Going to find that you entered your pleas of true to counts 1 through 7 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. But I'm not going to do that today. I'm going to continue you on probation. I'm going to order you to enter and successfully complete the cognitive track of the ISF program. You will be on 0 tolerance. If I'm telling you, I mean, if you are back in here, I really am going to see all of this. I see everything every time. And there's not going to be negotiations. There's not going to be, let's give you less than the 10. You've agreed to 10 years already. If you violate, it's 10 years in prison. And you can see your grandbaby when she's 5, 6, or 7 when you parole out. All right, so that's what's at stake, is a 10-year sentence. Not some lesser, maybe just 2 because you couldn't find a ride. You agreed to it, it's all yours if you violate. Does that make sense? All right, go back with the bailiff. Good luck.
In a surprising decision, the judge grants Jamie one final lifeline. Despite 7 violations and a long criminal past, she's being continued on probation, but with 0 tolerance and mandatory completion of the ISF cognitive program. The message is crystal clear. Next mistake equals 10 years in prison. This isn't just about one case, though. It's a powerful snapshot of how the justice system juggles rehabilitation and accountability. If you found this case as shocking as we did, make sure to hit that like button, drop your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns. Until next time, stay curious, stay critical, and stay tuned.